And it was rushed through Parliament because of the urgency of the proposal. That was the political argument. But after that rush, it actually took the Ministry of Justice and the Ministry of Technology several years to come up with the first draft on how they could then actually implement data retention. And why was that? Well, that was, among other reasons, because that there were many more technical implications that were ever foreseen when they first did the anti-terror law. And the ISPs in Denmark went out pretty strong in the press and really opposed it for a number of reasons that I'll come back to. So the interesting thing here, and this is why I've called it policy laundering, DKEU, is that when the process starts at EU level, we have data retention stipulated in our anti-terror law, but it's not implemented, and there hasn't yet been a proposal that could gain wide acceptance amongst ministries and industry in Denmark. So it's not a reality, but the process starts at EU level, and actually the Danish Minister of Justice is very active in promoting it at EU level. And even there were even quotes in the Danish press with arguments such as the data retention at EU level is building on the positive experiences from Denmark at a point in time where we hadn't been able to implement it for 3.5 years. So that was quite ironic. And only after the EU directive was adopted in February this year, they were able to rush it through the new executive order that was adopted this September. Yeah, this is a quote that is often quoted from our Minister of Justice. That was at a point in 2005 where the Parliament were very critical towards the European draft. And she went out and said, are we most afraid of the European Parliament or of terrorism? If the Parliament cannot help, then MIPs are not adult enough to take part in the discussion. So this was an illustration of the way that the debate was going back and forth at that point in time, and it was really hard to raise critics also at the national level. If we then look at the implementation of data retention in Denmark, the current executive order that we have now, to a large extent it follows the EU proposal. It's data that's generated or processed in the ISP's own system. There is no obligation on ISPs to invest in new system, in new technical equipment. This was one of the key areas of concerns that the ISPs had. They were afraid that this would be very expensive. They also had some principal arguments, but the cost argument was very strong. They didn't want to invest in new equipment. So this no obligation on ISPs to invest in new systems, I think, was part of the compromise why ISPs in Denmark have now accepted the draft or the order. With regard to the scope, it includes the commercial ISPs, whereas the non-commercial ISPs, libraries, universities, and smaller house associations are excluded. It includes session logging, which is something new compared to the EU directive, which I'll come back to. And it also says that there should be 24/7 point of contact at the ISPs. And for that reason, there should also be some security cleaning of some of the staff at the ISPs that can assist the police in handing over the data. If we look at the type of communication devices that it includes, for fixed line and mobile phones, it's pretty much the same as what Ralph just went through with regard to the EU directive. I've underscored last cells ID and physical location because that was the only difference we could find on this one compared to EU. But then if we look at the internet data, then we have this this provision on session logging. I'm still not certain that I completely understand the use of it, but it says that they must retain the first and last packet of every internet session of every individual user, or every 500 packet. And the ISPs I've spoken to, they said that this first and last thing, they are not going to do that. So they will go for the every 500 package. And for that one, it will be the IP address, the port number, and the transport protocol. And then the rest of it is pretty much the same as EU level, except location and ID of hotspots. That's in addition.
Mentoring women, because there's this idea that women might at any moment become sexual.
With regard to email and voice over IP, there's also a funny thing, namely that it's only the ISP's own email services that is included. So for instance, if I use Hotmail or Gmail, it's not included, which when we come back to arguments from the opposition of this has been quite a key point. The rest is pretty much the same.
So he's mentoring her not because she's genuine,
So
but because he has
if we just take a short look at some of the arguments that have been raised by the opposition, then the opposition to this, as I've said, it's been digital rights, a Danish NGO that I'm a member of, or a board member of, which is involved in European digital rights, which I'm sure some of you have heard of. We've been active, we've been vocal in this, also the National Human Rights Commission, the Data Protection Agency, the Association of Lawyers, IT Political Association, and a few other organizations. But in general, it hasn't been that large amount of voices, also because Denmark is a small country. So. But if we go through the arguments, the first one I've put up here is that it implements a surveillance infrastructure. It's basically the data retention directive at EU level and at national level basically implements a surveillance infrastructure. So whether these data are used or ever accessed or not, the structure is there. The structure is there for future use, and it will take years to pull it back, if ever. I think this is very important to remember, because often we are told that but okay, I mean, these data will only be accessed if it's really serious crimes at stake, in the Danish case at least. But still, you have the surveillance structure there to an extent that you've never seen in the physical space. Also, the whole idea of data retention does not respect a very fundamental principle in a society based on the rule of law, a free and open society, namely that you are only pulled out for investigation is if there is a concrete suspicion that you've done something wrong. I mean, there's certain borders between the state and the citizen that law is set up to respect. And here you basically retain data just in case. It's not because that I'm under concrete suspicion for anything. All communication data is retained just in case. So this fundamental balance between the state, law enforcement, and the individual freedom and the reasons for basically crossing that line has been moved with this draft. And this is something that has been raised, for instance, by Article 29, which is an expert group of data protection agencies at EU level, and also by Privacy International in London. From ISPs, the argument often goes that they don't want to police internet users. Their business is to provide telecom. It's not to be policing. Then they would be in a different business. Another argument is that they don't want to bear the extra expenses. This is a waste of money. It will cost tons. In Denmark, they've estimated between 100 and 200 million Danish kroner is what it will cost them each year. Yeah. And because there are these many exemptions, there are all the institutions that are not included, and there are also all the services that are not included. So basically, you're building this expensive, invasive surveillance infrastructure, and it's relatively easy to circumvent it if that's what you want. It's also, from an individual user point of view, relatively easy, at least if you have some technical knowledge, to disguise your own communication. And finally, there is still very little data, very little information on the actual effect of this provision. So we are rolling out this very strong measure, and you know very little about will it actually help. I mean, the whole point of it is to prevent terrorism. That's why we're doing it. So, but we don't know very much about whether it will have that effect to any extent, because it's not really in practice anywhere. I've just taken this one quote from a tele manager at the biggest ISP we have in Denmark. He's been very vocal in the whole debate, and he says the ambition that all communication must leave track to be retained for police investigation is simply against the basic philosophy of our society. This part I like a lot. And then comes the second part. It's also contrary to the way tele systems are designed. So what do we do next? Data retention in Denmark is a reality now. At first it was hard to get it through at the national level, but after it was adopted at EU level, the battle was pretty much lost in Denmark. Industry has accepted, but as Ralph mentioned, and as Patrick will also talk about, there's a growing opposition in other EU countries, not least Germany. There is a legal challenge in Ireland at the moment of the directive, and we don't know. I mean, if I'm to have a little bit of optimism, it might have an effect on some other countries, including Denmark. Also, at the Danish level, we will need to do a review of our anti-terror legislation and the specific provision on data retention. In the first half of 2007. So there's also a slight chance to open some arguments, but also to be realistic, it's probably very unlikely that it will be pulled back at this stage.
So we're seeing a lot of this stuff, and the problem is that, first of all, women are placed in a position where they're told they have to choose between work life and home life.
Thank you, Rike, for that overview of what's been happening in Denmark. I will now give you a short rundown of opposition and resistance to those plans on data retention. We haven't given up all hope yet in Germany, and we hope that we can do something about it either on the political level before implementation, or if that's not possible, on the legal level after implementation. So let me first show you the legal arguments that we put forward against this measure. First of all, first argument is that there's a lack of a legal basis for this directive on data retention. The European Community can only legislate in certain areas, and public safety and law enforcement is not one of those areas. We've had a ruling of the European Court of Justice earlier this year on the transfer of passenger name records to the US. You might have heard of that. And the European Court of Justice annulled the European Community legislation on that, saying, I can quote that from the decision, that decision concerns not data processing necessary for supply of services, but data processing regarded as necessary for safeguarding public security and for law enforcement purposes. So the argument goes that the EU may only legislate on matters, on data that is necessary for a supply of services, and the transfer of data to the US is not necessary, just as much as the retention of communications data is not necessary for the business of ISPs or telcos. So there's a good chance, and I'm pretty sure, that this directive on data retention will be annulled on the basis of a lack of a legal basis. The reason why the EU has decided to implement data retention as a directive is that this judgment of the European Court of Justice has not yet